Thank you. I want to leave time for a question or two, but Professor O'Sullivan is champing at the bit over here. She's been taking notes, and as our panel contrarian, I wanted to give her a chance to respond.
Well, actually, my argument that the privilege waivers don't undermine the policies behind the attorney-client privilege, I don't think anybody's taken issue with that. And actually, I think Bill agreed with me that it doesn't change the incentives of individuals to speak or not speak to corporate counsel. It's my understanding, and you guys can correct this, that part of the reason counsel should give upjohn warnings, what I always think of as upjohn warnings, that is, I don't represent you, right, and I can waive, the company owns the privilege and we can waive it, is precisely because of the problem that Ellen raised, which is you don't want a misunderstanding about who the corporate counsel represents, because then you get into this messy thing where the corporation wants to waive and the individual says, no, you represented me. And you want to avoid that problem. Now, as I understand it, there's something called the Sklar warning, which comes from Computer Associates, where some people feel the need to tell the people they're interviewing that, basically the government can prosecute you for obstruction if you lie to me. It's just gotten ridiculous. But in any case, okay, so...
And there is a Ninth Circuit case that says that the upjohn warnings now have to be in writing. I don't know.
Oh, that's interesting.
Yeah, that they have to be in writing.
Well, it should be. It should be something that's very clear. Now, as far as the bill that's pending, I have to say, I don't think it's going to be in the slightest bit effective. I don't think it's going to change the calculus. First of all, there's no way to enforce it. I have a funny feeling that you all are not going to be all that excited about enforcing this bill or coming up with remedies. And also because all it's going to do is change this discussion to an underground discussion, what some people call the kabuki. So in other words, I'm not going to ask you for a waiver. That would be against the law. But I want a waiver. It's very clear. I don't have to ask you for a waiver, right? And so, I think there was a significant question about whether or not the bill is effective. And, part of my concern here is that it has absorbed a tremendous amount of resources and energy of the bar to pursue something that I think really is not the point, right? You could take all those resources and redirect them to something that would make a difference. For example, lobbying Congress or perhaps litigating. I think as the more, Andrew is right, that it's much more productive to litigate the issues of the standard of corporate criminal liability. The Ionia case is not that's a very good brief. I urge you to read it. So it strikes me that there is a downside to focusing on the attorney-client privilege.
Can I comment on that, Jill? I've often said this. I'm not sure that people really believe me when I say it. The fight that corporations generally have over the attorney-client privilege is not to keep stuff from the Department of Justice. Because typically, most corporations, unless you're running the Corleone Family Foundation, most corporations want to be good citizens and cooperate and get things done and get on with their life. And I would oftentimes find ways to say, look, I can't tell you what Roscoe said to me, but go talk to Roscoe and ask him where he was at 2 o'clock last Tuesday, And so I would try and help him that. The concern isn't that I give it to the government. The concern is that once I give it to the government, I've waived my privilege, and I have 2 now, at least maybe 3, problems. I have state AGs that can come after me because it's no longer privileged, and I'll give them a roadmap. I have plaintiffs' counsel and class action lawyers who are only, frankly, look, I used to do class action plaintiff work. I know. They're in it for the money. I'm sorry, that's what they're in it for. And number 3, now Congress. Right. And so if what you disclose to the Department of Justice in very candid ways that may be ambiguous, and all of a sudden that's going to be used to come after you from a civil point of view or from a public relations point of view or in a different forum, that's the problem. Most of us don't mind giving it. What's the worst the Department of Justice can do? What'd you say, $25 million fine for that's nothing. Not $25 million, I'm sorry, it's not a big deal. I'd rather not pay it. But it's not a big deal for a corporation that is facing a $5 billion settlement demand in the class action that follows upon it. Well, so when we look at it, that's why people get so exercised, not so much to protect the DOJ, but from the others.
Rule 502. I'm sorry, the Rule 502. When they tried to amend Rule 502, the federal rules, the privilege rules, to put in place a selective waiver doctrine, and it was my understanding that the defense bar killed it. Because if you get a selective waiver doctrine, that is, turning it over to the government does not mean you waive to other people, then what will happen is you can't resist the waiver, right? You don't have
Right.
that argument anymore. So it was a shame that died.
And there is I apologize, I don't know the case, there is a selective waiver case that is going to be heard by the D.C. Circuit. And I believe there's only one circuit, that's the 8th Circuit, that has selective waiver. And maybe momentum, I don't know, but we'll see.
Well, please join me in thanking our panelists for a very thought-provoking conversation.